litigation. But when you go into that, how is it possible for them to decide? What I found, there are 5 judges. Of the 5 judges, one of them is called a rapporteur. And what he has done during the last 6 months after the pleadings have been completed is to go through the pleadings line by line and raise questions in writing to both parties. And he had got the replies of the parties in writing. So by the time the final hearing came, they knew the case inside out. They knew what are the real ticklish issues which need to be resolved. Therefore, they say it is 10 minutes for you, 5 minutes, and even though they reserved 90 minutes to the questions were over in 40 minutes. So the bench adjourned, and then the decision came. While it looks like it's impossible, I would say, in an Indian type of situation, where the courts are overloaded. A judge hears 70 cases, 80 cases in a day, and he has to read everything. After he reads, 68 of them will be sought adjournment from one side or the other. And he may not be continuing in that position after another 3-6 months. He may have a different portfolio. So maybe some of those things will not work. And that is probably, again, the issue with the US. The judges read, they have the judges' clerks who have read, who have done the research, give them the background. So everything starts off only with questioning. It is not that I start explaining what my case is, what his defense is. We take 2.5 days to do that, then only. Here they have read the case, they have understood it, and straight away it comes to the question. So some of the problems we have is that. So that is the, what I really wanted was, yes, the answer I said yes, jokingly, but yes, that definitely arbitration would definitely be an answer, because we can cut out many of these procedural delays and try to come to the crux of the issue. And that is why what demonstrate with the experience what is the position. I think if that comes through and it works well, I think that definitely will be a very good answer to all the problems.
Jack, what has been your experience in mediation? The question that one aspect of settling disputes is mediation. I believe a large number of patent suits and even trademark suits are settled in the US. What has been your experience as far as settling mediation and trying to arbitrate matters in the US, particularly IP matters?
There is, in fact, an overwhelming amount of settlement, but it's generally done not through pure mediation as an alternative dispute resolution mechanism, but through the courts. My first time in India was in 1989, and I have been returning ever since. And having also met Praveen in 1989, through him I learned a tremendous amount about the way the Indian court system operates. And in 1989, for a case to be argued for 2 weeks or 3 weeks made a lot of sense to me, because we were in basically a pre-computer age. Communication was more difficult. There was less access to court records and to prior cases. And so it was really incumbent upon the advocates to do a lot of explaining and even educating to the judges. I wonder whether that is still the case, because we are now in an age where there is access, and where judges are well aware, and the ability or the necessity of educating, I think becomes less necessary. So in the U.S., and you're absolutely right that in the U.S. we really mostly go by written submissions and written proceedings. We also are very privileged in that judges have usually not simply one law clerk, but they'll have several law clerks whose job is to really understand the case and to brief the judge, so much so that in most cases, when judges have the oral hearing, their minds are pretty much made up. They go into the hearing to be able to question the attorneys, to be able to resolve issues that they may have ongoing in their minds, maybe to try to even get arguments to convince them that their preconceived notions are in fact correct. But most judges, in confidence, will tell you that they very rarely change their mind as a result of the oral argument. And so for me, that has, the Indian situation has become actually a lot less understandable than it was when I first learned about it from Praveen. Judges control the case, however, very greatly. And because of our extended period of discovery and pre-trial proceedings, what judges will do is to try to promote settlements. So it may not be through the appointment of a mediator, although that's not an unprecedented occasion, but in pre-trial conferences with the judge as the case is proceeding, before there actually is the trial, or if it's an appeal, the oral argument, the judge will put a lot of pressure, in many cases, on the parties to settle. And as a result, settlements occur very, very greatly. In addition, one final thought, because I've been talking too long, but in addition, oftentimes